I just maybe need to reflect on this further, but I thought if you encourage something that is clearly going further than ending up being a party through complicity, which could be passive, than anything else. But let's just come to your in your memorandum, you identified two different definitions of torture. One was a broader one, which you link to the UN Committee Against Torture, which you say is broader, or it appears from your evidence you accept is broader, which, as you put it, includes tacit consent and acquiescence, and includes, as the chairman intimated in his intervention, constructive as well as actual knowledge that torture was taking place. You then go on to identify a narrower definition, which stems out of the conclusion of the ICTY trial, which you've identified, which has those three components. And I think they are they? I think all three elements must be established. So the and elements: knowledge, contribution or way of assistance, which in turn has a substantial effect on the preparation of the crime of torture itself. And clearly, the first one is wider than the other, and doesn't require active encouragement, in my view, just tacit consent and acquiescence. And in the conclusion of your submission to us, you tend to, I think you say, that you would go with the latter, narrower one. Conclusions, paragraph 25 of your submission, having regard to the requirements of the law, proper investigation of any possible complicity in torture by persons associated with the British authorities would have to focus on key issues of fact relating to, and then you go 1, 2, 3. And then you give the... So you're actually saying that, in your view, because it's your conclusion, it's the narrower definition that applies, and if we took that view, we would be taking a definition narrower than tacit agreement and acquiescence.
I don't think, perhaps it's a drafting point, I don't think that was my intention. The Committee Against Torture, established under the Torture Convention, has a very limited case law on this. I mean, you've got it all here, that's all they've said on this subject. So you read it very carefully, you try to understand what it is they're saying. There's some jurisprudence, the Yugoslav War Crimes Tribunal has some. I think they essentially go in the same different direction. If you look at the examples that are given by the Committee Against Torture, if you're a doctor in the room, you never touch the individual, but you're there to make sure the individual is in a sufficient state to continue being abused. That is complicity. If you are a policeman who's been informed that an individual is at immediate risk and you do nothing, that constitutes, here I'm paraphrasing the committee, a form of contribution. So it's a negative or positive, it's the flip side of the same thing. I think the three elements essentially have to be present on both standards that have been applied, and I don't really make a point as to which is narrower or broader. I think perhaps what might be slightly unclear is what is meant by the term contribution. Contribution can include a failure to act, turning a blind eye.
Well, I hesitate to give you more work, but if you are able to just look at because I read it as I read it there, so I'd definitely like to know your view.
I'll put in a supplementary page on that.
Before you go to the third element, I just want to ask you a question about the third element, where it says substantial effect. I mean, supposing UK government had sent the CIA, and the CIA said on behalf of the UK government to the Uzbeks, please stop torturing, and meant it, and the Uzbeks would have just carried on anyway. It made realistically, absolutely no difference whatsoever to what the Uzbeks did, because of that's their record. So how would that affect the position? Because there'd be no substantial effect one way or the other, because they take not a blind bit of notice what we had to say, as in fact they happened when it was raised with them.
That may be the case, or it may not be the case. Again, I'm not sufficiently close to the facts of that particular scenario your previous witness was, but one can easily imagine a situation in which where a government becomes aware that certain practices are being followed, it makes it very clear that it does not accept that such practices are tolerable, and that if they continue, it will take further steps in order to indicate its displeasure with what's going on. The do-nothing option, in effect, can be seen as encouragement, and in that sense may constitute in an indirect way a contribution to what is happening. I mean, it's not that helpful what I've just said. Everything turns on the specific facts of the scenario. I'm afraid I've not directed my mind to the Uzbek situation. I've directed my mind over the last 4 years a great deal to the US situation, where the facts are now, I think, rather clear. And on those issues, I can say probably...
Well, maybe, because this is... Can I just finish the slide? Because this is my last real point here. Because there's an argument that what the British government is doing is illegal, and there's another argument, which I happen to say that I'm happier with, which is that as a matter of policy, the government should change its policy. Okay? And part of the argument for that is that the law doesn't really help, because let's say in the case of America or Uzbekistan, the facts are that Britain, as part of the facts, says don't do this, and sends money to train people in how to do interrogation, which does not, and does all that, yet still, citing the, what I don't want to call the Bingham Doctrine, accepts the recipient, okay, sorry, the caveat, receives intelligence, which it says it's not going to use in proceedings, but looks at, as it feels it ought to, in case it gives evidence that there is a bomb, and then it can make its ticking bomb, if you like, and it can make its decision. In those circumstances, the whole of those facts are, I don't think, and are you saying that those facts are consistent with knowledge that torture is taking place, yes, tick, contribution by way of assistance, just passive receipt, plus thank you for sending us intelligence, those words, and that has a substantial effect on the perpetration of the crime of torture itself. This, as the chairman says, this is a state that does it. In fact, it's probably a state we're going to seek to have a memorandum of understanding with, because we know they do it. It just seems to me that it's difficult to make a legal case on that.
I wish I could give you a yes or a no answer, and I can't. I think there is a point. There is a point on a factual continuum where passive receipt on a regular basis can be seen as becoming active encouragement and therefore complicity. Right. Where on the continuum that happens is very fact dependent, and I don't think it's helpful to give a general yes/no answer. The point that you've raised about a legal case, frankly, is exactly the situation that President Obama now finds himself in. He chose his words last week very, very carefully. He said, and I think he was right to say, interrogators who relied on wholly erroneous and in fact outrageous legal advice in good faith should not be targeted by way of prosecutions, and I think that is the right approach.
Okay, well, we'll come back to that later on. We'll have on to that.
I don't know whether you heard the allegations made that Lady Thatcher's government said we do not use it, and later on we do listen to it. Does that not make it automatic? The moment somebody has said, yes, even we didn't accept this, now we do accept it, that surely must be encouragement or complicity. In my mind, the moment you say yes we do, when we had been before saying no we don't, that makes the government complicit.
Well, let's take a hypothetical fact scenario. Let's assume the situation in country A was, for a period of 10 years, we won't touch certain categories of intelligence or information because we understand them to have been obtained by illegal means, torture. And then a change of policy is taken internally in the government, and it adopts the direction that you have just suggested. We will receive it, we won't use it in court proceedings, but we reserve our right to use it for other purposes. I think the crucial question then becomes whether that change of policy is in some way communicated to State A. Because if you communicate that change of policy, then plainly you are potentially crossing that line into encouragement.
What I find hard to believe about this Mrs. Thatcher analogy is this, that somehow the government of Mrs. Thatcher said to the CIA, please don't send us information obtained under torture from Argentina or wherever it happens to be, because that was the dictatorship at the time. And then suddenly, after 9/11, MI5 and the government, MI6 and the government suddenly say to the CIA, you can start sending us out dodgy information now. I just don't see that as a credible scenario. I suspect the CIA would have sent all the material they had all the time anyway, no matter what Mrs. Thatcher may or may not have said.